We are starting this hour with live court. This is the case against Michael Barisone. You may know he was an Olympian, a writer. He was then, and guess what? He shot her. It's not contested. The victim in this case, Lauren Kanarek, testified for the prosecution, and they say he intentionally shot her. This is a case in New Jersey. His defense? Not only an insanity defense, but also that he then shot her in self-defense because he was afraid of her and her fiancé. We're taking you back live into court on the stand. The defense has started their case. There's a psychologist on the stand under cross-examination by the prosecutor.
Specifically number 21. Does it indicate the individual is excessively committed to seeing the world accurately?
Yes.
And realistically?
Okay.
And you would agree with me you didn't put that in your report?
No, I don't need to on that, because for the simple reason that if an individual has a delusional disorder, I did indicate from that it's not going to be picked up. So this report and say it doesn't fit in with everything I've written. The point is that I'm looking for things that overlap, that agree with each other. So that's a factor that I use in terms of generating a report. But there's no way that you could write a report and think that you could put every single piece together. You have to use some kind of clinical judgment.
Well, you'd agree with me that if there was a common thread here of any of the things we've talked about with these other reports, and other tests rather, and you didn't, but that means that you ignore it.
Ignore it. I also just said to you previously from on the assessment said delusional disorder on the Rorschach. And if you're trying to imply that just because he has a clear view of reality, that doesn't necessarily.
You also didn't put any of these quotes in your report or these passages in your report and then distinguish them or differentiate them, did you?
I don't believe I quoted. I thought I summarized what I saw was in the reports.
Well, we just pointed out a number of things that you didn't put in your report, correct?
You'll find that with all the testing that's done.
And lastly, on page 12 of 13, number 24, you indicated earlier in your testimony on direct examination that the defendant was incapable of understanding the nature and quality of his actions?
Yes.
Does page 12 indicate the individual is capable of maintaining a connected flow of associations in which ideas follow each other in a comprehensible manner?
Okay, but you also recall from, it says that, but you also recall from our report that said it was a very low number of responses that were produced. I also wrote in my report the least number of responses. You have to have 14 responses. If you have less than 14 responses, you don't have a valid profile. And the fewer the responses are, and it's discussed with Wood and his associates, you can push down the pathology. I mentioned that in my report. So you need to take that into account, that you could have a suppressed level of pathology in it, given the fact that the number of responses were very low.
And I think my question was just that that was a indication that you received from the tests and from the scores, but that you didn't include that in your report.
But I just said that you could read this, but if you also know how many responses are given in the score, and I have a section in my report on that, that you could have a spuriously low sign of pathology in the report, given you have very few responses.
All right, doctor, let's move on to the MMPI, the MMPI-2. Did you rescore this test?
I ran it through the computer.
Now, I think you testified on direct examination about the MMPI-2, correct?
Yes.
And you testified in particular with respect to scale 6. Can you remember, or can you remind the jury what scale 6 is?
Scale 6 measures paranoia.
And it's fair to say that none of these scale titles, the names, shouldn't be interpreted literally.
No, you should look further into the test. You should look at the subcomponent scores, PA1, PA2, PA3. PA1 shows delusional thought content of a very serious nature.
And doctor, I'm just asking you about scale 6.
Yes.
So scale 6 is titled paranoia,
Yes.
but it doesn't literally mean that it's testing paranoia.
Well, I just said literally that you have to look at other scales on there. And if you literally look at other experts in the field, they're going to say it measures a delusional disorder, a score of 90.
So the high score of 90 on scale 6, you would say is indicative of someone with delusional disorder?
Yes. And not just simply on that. I also...
And doctor...
All right. Okay.
Well, isn't it true that people with high scores on scale 6 rarely endorse the existence of delusions?
I don't believe that at all. I've never seen that.
Who is James Butcher?
Oh, I know James Butcher. He's one of the MMPI figures.
And I think you cited him in your report as well, correct?
I might have.
He's a reputable
Yes.
person with respect
Yes.
to the MMPI-2. Have you ever looked at his book, Using the MMPI-2 in Forensic Assessment?
No.
Judge, if I may approach, I don't have this marked as an exhibit.
All right, well, what's the next exhibit number, just so we have a reference?
I believe it's S454.
That's 454. Counsel, was that turned over to us?
It's a
Do you have an
treatise.
objection, Mr. Blank? Yes, sir. Come to side.
All right, that's another sidebar. So I just want you all to know there's nothing wrong with your TV. The audio issues have been happening off and on. It's outside of our control. We're going to take this opportunity to bring in our special legal analyst with us this hour in studio. Still with us from last hour, criminal defense attorney, former prosecutor Noah Pines. And now want to welcome in San Francisco, criminal defense attorney Joseph Tully. Thank you for joining us, Joseph. Let's do a little insight into trial strategy. And the reason I say that is because, Noah, you mentioned something. This witness on the stand is a defense witness in this case, testifying as to the reason why they're saying it's an insanity defense. What did you say to me, Noah, about how you're able to tell if it might be what we might consider a professional witness, someone who's been up there on that stand before?
Yeah, it was just a minor thing, but he was pouring his water, and if you've seen someone who's never been on the stand, they pour their water right in front of them, and typically those pitchers burst all open. He turned to the side and made sure he poured it so it wasn't on him, and if it got wet, it wouldn't get any of his papers wet. To me, that's a professional witness, someone who knows how to pour water, something small, but something that's a big tell for me.
And it's those little details that make a difference, because, Joseph, the defense did bring out that he has testified at least 50 times as a defense witness. Having said that, how do you think his demeanor is doing on cross-examination? I mean, the prosecution just had to say to him, all right, I know, let's not get ahead of yourself. Let's listen to my question.
I thought that moment was one of the few mistakes that this witness made. I would give this witness, the time that I've been watching him, an A, if not an A+. I mean, he knows his stuff. Lawyers in court, when we have to cross-examine an expert, we have to become experts ourselves, but it's very clear that this expert knows his stuff over the prosecutor learning.
All right, let's go back into court. I understand that they may be back from their sidebar.
Six also often express their hostility overtly and rationalize it as a result of what others have done.
Yes.
And you indicated this defendant, Michael Barisone, scored high on scale 6, exceedingly high.
I indicated that a T-score of 90. I've never seen in my career an individual score that high on scale 6 with validity scales that are within normal limits. And the reference you're giving doesn't give very high score, doesn't give any scores. It just gives a general discussion.
But you agree with me that James Butcher and others wrote in that report that an individual who scores high on the scale for paranoia rarely endorses the existence of delusions.
It's incredibly misleading. You would agree with me that on the references that
I'll ask the questions respectfully.
Just answer the questions, please.
So you agree that you just read that in that book?
Yes, I read that.
Now, you indicated that some of the tests that you administered, the defendant showed difficulty with his concentration.
On some of the tests, yes.
On the MMPI-2, which is S434 for identification, and we're going to pull that up for you now, Doctor. Michael Barisone endorsed a number of persecutory ideas.
Yes.
And you'd expect that of a criminal defendant who's on trial?
Not necessarily. I would expect that someone who has a delusional disorder to get a score of 90 on scale 6 and a score of 105 on scale PA1, and also to get a score of 88 on the Caldwell index.
Well, if he indicates in respect to question 99, someone has it in for me and says it's true.
Yes.
You would expect that for someone who's been charged with a crime.
No, I just think I just don't agree with you.
Now, with respect to the MCMI-4.
Yes.
I don't know if you specifically mentioned that on direct examination.
Well, I administered it. However, I tried to check out the cut scores by looking up Rogers, and I didn't use it, even though the test came out in the same direction as the other tests, because the validity scales were weak on that.
Why did you use the MCMI-4?
It's a legitimate test. I wanted to look at personality disorder in him. However, I wanted to look at the current cut scores, so I looked up Rogers, and he didn't have any information on that, and then I decided not to use it, given the fact that I wasn't sure if it was valid, the conclusions.
Doctor, you mentioned the PAI test on your direct examination. Do you recall that?
Yes.
And specifically with the PAI, I think you testified that you did validity testing with respect to that test.
There's validity testing on there.
Judge, this has been marked as S436.
Fine.
Doctor, directing your attention to page 2. At the very top of every page on this document, Does it indicate warning validity scales indicate hypotheses may not be valid?
Certainly does.
And this test itself actually indicated that there was the possibility of deliberate distortion.
I also indicated in my report that I used Richard Rogers' cut scores for NIM and MAL. They're different from the scores on this test. The cut scores for Rogers, the NIM, negative impression management, has to be above 110, and the MAL, which is like an index score of a group of different scores, has to be above 5.
And they are getting into the validity of these tests that the psychologist administered to the defendant. We need to take a break. When we come back, of course, we'll continue to monitor our live coverage of the Barisone trial, but also we are waiting for the case of Oregon versus Nancy Brophy to come back to court following a lunch break, the romance novelist murder trial. We'll bring you both of those when we come back on the other side.
Free for 30 days.
Welcome back. Let's bring you up to date. Right now, the romance novelist murder trial is still on a lunch break. We're going to continue monitoring that for when they come back to court. Earlier today in that case, we heard compelling testimony from the victim's own mother. So we'll keep you posted on that case. In the meantime, we do want to take you back to the Olympian who's been charged with the attempted murder, 2 counts, for shooting Lauren Kanarek as well as her fiancé. And we're going to stay there and take you back to court. I believe that they are still in court. Cross-examination is continuing of the psychologist who evaluated the defendant in this case.
With everything in the report, I would use my judgment on the report. The test gave 2 things. It gave validity scales, and it also gave clinical scales. The validity scales said that the test was accurate.
And where the results of the PAI that you have in front of you as S46 didn't match your ultimate diagnosis, you didn't put anything in your report about why you ignored that or why you distinguished it.
I indicated that I'm not putting down malingering, given the fact that there's no evidence of feigning on this test, because I used more accurate cut scores.
So where it says there's the possibility of malingering, you're saying that feigning is not indicated at all by this test?
Correct.
Doctor, you also mentioned that you administered the 16 PF test.
Yes.
And I know you mentioned several of the factors. I don't think you mentioned factor L. What does factor L measure?
Vigilance. High suspiciousness.
Did Michael Barisone have an extremely high score on this scale?
Yes.
His scale, or his score rather, for this scale was at the top of the range.
Yes.
And a score like that would suggest problem.
Again, some technical difficulties, not on our end. We apologize for it, though. It's happened throughout the day. You can see the screen is frozen. It's not your TV. I still want to talk with our guest legal analyst because we have 2 attorneys with us, Noah Pines and Joseph Tully. Gentlemen, we were just talking a little bit off air, Noah and I were, Joseph, about the fact that this prosecution is asking a lot of very specific questions about all of the testing and tools used by the psychologist when he evaluated the defendant. How does that play with a jury, in your opinion?
Again, he's trying to take on a very good expert on that expert's turf. And to me, it's appearing like it's a swing and a miss, 90% of the time. He's trying to build a case where he can say to the jury during closing, oh, this is a lot of hogwash. This is a hired gun coming in to say these crazy, even though, wink, wink, we all know that this is just part of the game that the defense is playing. And I don't think he's getting very far.
All right, Noah, in terms of trial strategy, how would you handle an expert witness? Would you two try to go through all the pieces of the evaluation or not?
Not like this. This is boring, one. Two is, these tests, it's not like this doctor made up these tests. These tests are tests that are used for, many years by many doctors. I always like to find a couple of things I can get the expert to agree with me on and then use it for my case. So pick 4 or 5 things that I can use against the other side using the expert, and that's the way to do it. And then I can say, hey, their expert said it. It's true.
Joseph, talk to us about the fact this is a unique case. We all know, I think, that to have someone say the insanity defense, right? They made me do it because they basically drove me insane and I was fearful. So you add to that self-defense. That's a little unique.
It is unique. Usually, I know in California that this kind of issue would normally be bifurcated. So first you'd go to have a trial on whether or not self-defense, whether or not the client's guilty, and you would argue self-defense. And only if you lost on that issue would you go to the issue of whether or not insanity is applicable. Here they're sort of rolling it all together, and as you're suggesting, there could be some synergy by saying that, look, all the evidence that they drove him crazy comes in to play here. The jury can consider that in terms of self-defense.
And it's interesting because I did a little research. I'm such a trial nerd about New Jersey and found that specifically in that state, there's been cases appealed. And the result is if you're going to do both of these defenses in New Jersey, you do them together at the same time. So it's every state's a little bit different with the laws, with the nuances. All right, Noah, do you expect that we're going to hear from Michael Barisone, the defendant in this case, given he's claiming insanity defense and self-defense?
I would think that that would not happen. I just can't imagine putting this guy on the stand. I don't like to have my clients testify in general. It's always their choice, but typically defendants mess up a case more than they help it. So unless there's something really, really important that needs to get out, in this case, I can't see how this guy can help himself.
And we have certainly seen trials and covered trials here where that defendant speaks and everybody kind of says, oh no, this does not bode well for the defense. We'll have to wait and see what happens in this case. We're covering multiple live trials here on Court TV. We do need to take a break. Don't go anywhere. We'll be right back here on Court TV, your front row seat to justice.
9.
Welcome back to Court TV. I'm Ashley Wilcott. We're covering 2 big trials here. One involves a romance novelist on trial for the murder, and the other, a former Olympic equestrian on trial for attempted murder. Barisone is accused of 2 counts of attempted murder for shooting 2 of his former tenants. The defense is calling their final witnesses to the stand. And out of Ohio, let's go back into court and see what's happening.
Questions about amnesia on direct examination?
Yes.
And you indicated that you diagnosed the defendant with dissociative amnesia.
Yes, localized.
And I think you testified on direct examination that it could be dissociative amnesia.
Yes. I chose to diagnose that.
When you were asked whether you were sure of that or made that opinion within a reasonable degree of psychological certainty, is that the same as it could have been?
Yes. More likely than not.
Now, you agree with me that there's no memory disorder that's selective just for criminal behavior?
I don't know what that means.
Was there anything in the DSM that would indicate someone could have a memory disorder that's selective just for the time that they're doing something that's criminal?
It's possible. I wouldn't rule out any of that, and I wouldn't use the word malingering. Because if you're going to use the word malingering, you have to show a test that is positive for feigning. There's no test that I gave that show any feigning.
So my question was,
yes.
Is there any diagnosis in the DSM that deals with someone's memory being selective just for the time when they commit a crime?
No.
Now, you'd agree with me that the DSM also indicates that feigned amnesia is found more commonly in individuals with legal problems.
Well, I think the reference is not, they say they don't use feigned, they use malingering amnesia, right? As a V code. The V code in that book, I think on page 715 or so, it basically states that in criminal situations you should suspect that there's malingering, but it doesn't prove that there's malingering in this case, because it's not just a simple criminal act, it's the fact that he can't remember something that was incredibly stressful.
And my question was, isn't it true that feigned amnesia is more commonly found in individuals with legal problems?
I don't know that. I don't know any data on that.
Is it true that feigned amnesia is more commonly found in individuals who wish to escape stressful situations?
Dissociative amnesia often comes with people who are in stressful situations, but they don't call it, you're using a term that doesn't exist. You're saying feigned amnesia. The term that's in there is dissociative amnesia. That's an emotional type of amnesia.
Judge, I'm going to refer to the DSM-5 again. This hasn't been marked.
All right.
And I'll mark it when we're done with court, Judge. Doctor, you just said that feigned amnesia isn't a term that's in the DSM?
Not that I know of, with the diagnostic number.
I'm going to direct your attention to page 298. You would agree with me
Okay, go ahead.
that this page talks about dissociative amnesia?
Yes,
That's the diagnosis that you came up with for Michael Barisone.
correct.
You would agree with me that there are a number of things listed after the criteria, diagnostic features,
Correct.
associated features, risk and prognostic factors.
Yes.
And if we get here to page 301, it says factitious disorder and malingering, correct?
Correct.
And you'd agree with me that the book says feigned amnesia is more common in individuals with legal problems, correct?
Okay. Yes.
It also says feigned amnesia is more common in individuals with a wish to escape stressful circumstances.
Okay.
Does it then go on, many individuals who malinger confess spontaneously or when confronted?
Well, it's a strange article there because there's no specific diagnosis for feigned amnesia. It doesn't have a number. There's no number.
Doctor, if you recall my question, it
Yes.
wasn't whether or not there was a number or whether or not there was a specific diagnosis. I asked you if the Diagnostic and Statistical Manual indicates that feigned amnesia is more commonly found in individuals with legal problems.
Possibly so, but that
You told us
criteria,
that feigned
that-
amnesia does not appear in the DSM.
when you look at malingered amnesia, it's wrong. I could show you the data 80% of the time. Now, I'm not saying that, anyway,
And doctor, I'm just asking you about your diagnosis.
yes,
You diagnosed the defendant with
dissociative amnesia,
dissociative amnesia.
dissociative amnesia localized.
And you would agree with me that in the comments or the follow-up statements about dissociative amnesia, it talks about feigned amnesia.
In that same paragraph, they use the word malingering and they use the word feigned. Those are two different concepts. I don't know if they made a mistake or what.
The authors of the American Psychiatric Association made a mistake when they published the DSM.
So look on page 715, I believe it's 715, for conditions V codes. And on that page, it discusses malingering. And those diagnoses, malingering, are wrong 80% of the time.
Now, you indicated, and we just read, rather, that it's true that individuals who malinger may confess spontaneously.
Okay?
You would agree with me at least that that's what we just read out of the American Psychiatric Association's DSM-5.
Okay, yes.
You would agree that Michael Barisone was overheard at the scene saying, "I had a good life."
Okay.
You would agree that he was overheard in the ambulance saying, "Is this real? And I need to wake up."
Yes.
You'd agree that in the ambulance he also said, "Someone drove down my driveway and said she was going to take my kids."
Yes.
You'd agree that the defendant was overheard later at the hospital saying, "They destroyed my life in the last 6 months and they took it all away."
Yes.
Did you ask him what he meant by any of those statements?
Yes.
Did he tell you that he doesn't know?
He doesn't know what they meant. He doesn't even know how his arm was broken.
And you believe the timing and substance of those specific statements is vague?
They're not vague, but you have to have a context.
Didn't you write in your report that they were vague?
Well, I asked him what they meant. I didn't know what they meant. I don't know what he's referring to or those statements are referring to. It's not clear to me.
Do you recall in the written statement that he wrote for Dr. Simring, where he indicated on a certain page that after the DCP&P worker got there and he was in his office, that he only remembered 2 or 3 things that were blurry at best?
That's in his report, Dr. Simring's report, but I didn't ask that what he remembered. I asked him the last thing he remembered.
The defendant saying he remembered 2 or 3 things and it's blurry at best is in Dr. Simring's report?
I believe it's in Dr. Simring's report, but or it's in the 91 pages. But I didn't ask him on that. I asked him the last thing he remembered.
So you didn't ask him what the 2 to 3 things were
No.
that he remembered after he was in his office, after DCP&P?
What he said he remembered was lightning bolts coursing through his body, feeling confused, had trouble breathing. It was like he was having a panic attack, and he didn't know where he was, what he was doing, and the next thing he remembered was waking up at the hospital.
We have to take a break. You've been watching the former Olympian murder trial, and I just want to point out this doctor on direct examination said that the defendant's ability to understand that he was doing something wrong was impaired.